Good evening, guys. See, a few of us are on. I made it just in time.
Sorry, what? At work? You gonna sign up?
Hello, hello.
Good
Hopefully a
evening.
few more are going to join us here in a few minutes.
Oh,
How's everyone doing?
good. How are you?
Doing good.
It would help if my speakers were on. I was like, why is everyone on mute? They're not on mute. Operator error. Was anyone at ELU today? Did anybody make it to employment law? No? All right. It was good. The AI session will make you squirm. It was interesting, to say the least. Awesome. Well, since we're getting a little bit of a later start, I appreciate all of you and giving me a little bit of grace so I could have my mom hat on until now. But we're going to go ahead and jump on in. If more people join us, fantastic. But we're going to go ahead and get in so that we can make sure we get through enough material to wrap up next week. Before we get started, I'd send out a few questions, and we don't have to answer, like each person doesn't need to answer all of them, but I am interested in knowing, as we kick off this unit, what are some risks the company that you're at has, because all of us experience different exposure based on our industry, maybe even location, just operationally how we're set up. What is a risk for one may not be a risk for another. So talk to me a little bit about some of the things y'all deal with day to day as it relates to safety, health, even just environmental risks that y'all may have.
Hey, Julia. So I work for Carter Blood Care, and so we're a blood bank company, right? So there's definitely tons of risks that we run into, whether it's just the needle exposure, right? Recapping needles or anything with the needles, right? That's probably a risk that a lot of people don't deal with. We also have different lab environments as well and manufacturing in a way. So we handle totally we have drivers, we handle lots of different risks. I mean, we have GPS now in the cars, so we have, different things, whether it's the accidents with that stuff, the DOT, so many different things with us personally.
Oh my gosh, yes, absolutely. The needles brings me back to bloodborne pathogens and all that fun stuff from my healthcare days and educational days. You do that as a teacher too. Yeah, and so many other things. Absolutely. Needle pricks. Oh my gosh. I still probably have nightmares in my sleep about needle prick and reports. Awesome. Thank you for sharing.
We have a lot of property managers that are out and about to different properties. I guess our biggest exposure, I think, today would be the driving and then getting injured on the properties.
Yes. Yeah. Anytime driving is involved, there's an immediate level of risk. Even if they're a good driver, it's everybody else, right? And if they're not a good driver, that's a whole other ballgame. So yeah, absolutely. Awesome. What about, are there any specific benefits that you offer to help employees both with both their physical and mental health? I would think of this a little bit beyond obviously our standard medical benefits. There might be special programs you have or EAPs that you offer. Is there anything kind of out of the norm that y'all are doing or even are thinking about doing in the future to help support your employees as it relates to, again, physical, mental, even just environmental pieces? Anything new out there?
I mean, we definitely have done some mental health webinars and lunch and learns and stuff like that at my company. And then, we have a EAP program, of course, right, with different counseling and lawyers and all those other resources available, of course.
Fantastic. Love it. Awesome. Well, I know it's an area, especially around mental health, where all of us are working on how we can continue to serve and support our employee population. That also actually came up today at employment law, and I don't think I knew this. I mean, it makes perfect sense, but I don't think I knew that this was truly like a law of sorts or regulation, but that your mental health coverage cannot be different. I'm probably going to say this wrong, but essentially what I took away was it can't be different from like your medical. So for example, if they have to pay a $60 copay to go to a medical specialist to go see somebody for their mental health, it cannot be $100 copay. Like, it's not supposed to be different. Which again, like, makes total sense, but it made me go, oh, I've never even thought about looking at my plan in that way. And so if you're not, when you go back to the office tomorrow, you might take a quick look. I know I plan to for ours, just to make sure the coverage is equitable, basically, and not more expensive. So anyway, cool. Well, we're going to jump on in. This is Unit 5, Compliance and Risk Management. If you are testing, I believe this is still 25% of the test. And again, as we go through this unit, definitely it varies from industry to industry. So things that I may talk on, you might go, that absolutely does not relate to me. It doesn't matter. It doesn't mean it doesn't matter. It probably just relates to you in a different way for your organization. So if you have anything to add that might help the group, please feel free to jump in and share, because I don't have experience in all industries. So I think this topic is extremely important, and it's an opportunity for all of us to learn from each other and take away some ideas. So with that, let's jump in. Get my screens pulled up. Okay. You have to click through so many slides just to get to the first one. Okay. So risk management, purely just defining it here, but it refers to the process of assessing and measuring risk and developing strategies to protect the financial interests of the company. So some examples of this go into some of our strategies, which are, it could be avoidance, it could be the transfer of risk, it might be mitigation of risk, or just accepting that there are risks that you have to take as a business in that, field. So I see a lot of the acceptance of risk to some degree is maybe those of you that have to have drivers out there. Like, you cannot run your business without that. It doesn't mean that there are not areas that you can reduce maybe and put some protocols and procedures to keep it as low as possible. But you're probably not going to completely get away from it. You're probably not going to be able to minimize it to zero. Again, I think of healthcare from my days there. Like, the risk is never going to be zero. I can try to mitigate it by making sure I'm educating people properly and that they have the proper tools and resources they need to stay safe to try to mitigate it. But I cannot just take it away, unfortunately. Again, going back to today's, like, maybe in the day when we have robots, that'll help. I don't know. But until then, where they, a prick of the needle isn't going to impact them the same way it does a human being. But until then, we have to just do as much as we can, and we're always probably accepting some level of risk. So just keeping in mind, these are some of the strategies that probably we're all dealing with. We're probably doing it without even thinking about it. Like, so many of the decisions we're making, we're not even realizing we're assessing our risk and managing that risk, because it's just so natural that we're doing it day to day. So let's jump into safety. Every organization is required by law to assure, so far as possible, that every working person in the nation is provided a safe and healthful working condition, and to preserve our human resources. So this is a requirement of all of us, and I'm sure we are all doing the absolute best we can to ensure that there are safe working environments that we are providing. From that, though, we come to OSHA, our lovely OSHA Act of 1970. So from this, it is the responsibility of each employer to provide a place of employment that's free from recognized hazards that are causing or are likely to cause death or serious physical harm to employees. The basic purpose of the acts are to reduce hazards in the workplace and encourage employers and employees to implement improved safety programs. So it was used as a tactic, basically, to say, you need to make this a priority. Probably prior to 1970, think of the environments, and it likely was not a priority. So employers were, placing a priority maybe on financial gains and not taking care of their workplace environment. And therefore, there may have been a lot more unnecessary injuries, deaths, things of that nature. OSHA also requires employers to maintain reporting and record-keeping systems that monitor job-related injuries and illnesses. So OSHA covers all employers and employees, except there's a small number of exceptions: self-employed individuals, family farms where only family members work. So if there are outside people, then that would no longer be exempt. Workplaces already protected under federal statutes, and state and local government employers and employees to implement improved safety programs. So at the end of the day, for the most part, we all fall under OSHA to some degree. You probably already knew that. I hope you already probably knew that. It's just a matter of what do we do to continue accomplishing this. So let's talk about the general duty clause. Each employer can be persecuted for violating this general duty clause. So that's something to take into account. I personally don't think I look good in orange. So I take these things pretty seriously. I'm sure you all do as well. So even if they do not violate any of the specific standards, if you are aware of or should have been aware of a hazard that could cause serious injury or death, you are still responsible. So from this, like I said, again, the general duty clause, each employer, we shall furnish to each employee a place of employment which is free from those recognized hazards that are likely to cause death or physical harm. So anyway, we're all in it. We're all in it at different degrees. I think I had shared originally, I've previously worked in healthcare. That was definitely, there was a lot more to take into account in terms of how we ensured our environment was as safe as possible. Now working in public accounting, there's a lot less hazards. Most of our people are sitting at a desk. There's not a lot of lifting. There's not, machinery. There's not a lot of these hazards that you otherwise think of when you think of serious harm. So the discussion question put out there is, some companies may offer incentives for safety. What would likely happen as the incentives for safety increased from minimal to very substantial? What are some of the things you think how would that kind of play out, if you will?
A reduction in accidents?
Hopefully, right? They're incentivized. Do you think it's possible, though, depending on, right, the incentive, is the reverse side of that is they're just not reporting the accident, right? I think that's just one of those things you have to weigh is, it's not wrong to offer incentives. I know a lot of companies do, and they pride themselves on going, 500 days. I think I was actually driving up 35 and I noticed the Miss Baird's bakery not that long ago was like 500 days accident free. And that's awesome. That's something to celebrate. Nobody wants to take that away. I don't know if they incentivize or what have you, whether they do or not. I think it's just depending on how attractive the reward is, you could potentially be discouraging people from making reports that actually should have. So it's just something to be mindful of and aware of, that even if you are doing this, that you're being very aware of what's going on. If somebody all of a sudden shows up one day with a, what looks like a broken foot, and you work with heavy machinery, that probably you ask some questions. Hey, oh my gosh, how did that happen? And just try to make sure it was not done at work. That maybe it truly did happen while they were out playing recreational soccer with their friends or whatever it may be. So just an awareness. Accident rates and how you calculate those.
Julia, real quick.
Yeah.
I noticed like a reverse side of something that we did, and it wasn't like an incentive, but like with the needle sticks, they were having to go do a drug test afterwards, right?
Yeah.
So we were not getting true reporting. We took that drug test part away from it and just wanted to get the reports, right? Because we wanted to get a report on it. Our numbers did increase at that point, right? So more people were willing to reach out. I just wanted to add that.
Yeah, because it's such a pain. I remember that nobody wants to go take those drug tests, and I don't blame them. But you're right. You need to think about what you're expecting when people make a report. Is it necessary? What is the desired outcome of that? Like, I know what the purpose is to having them do a drug test after a needle stick, but also to your point, is there an unintended consequence to us making that decision? Does it outweigh the benefit of it? So yeah, I think that's an excellent example in ways that we've got to just keep asking those questions. Is this still the right way, or the way that we want to do it? Are there possibly unintended consequences to it that we're not, we need to factor in to some degree? Yeah. Thank you so much for sharing, Tyler. That's great. Okay. So incident rates, it's compiled, the Bureau of Labor Statistics compiles incident rates for injuries and then does report those to OSHA. An incident refers to a recordable case, and we'll get to that in a little bit of what constitutes reportable, because not every little bitty thing is reportable. And they are based on cases per 100 worker years using 200,000 employee hours. So that's why you see that calculation multiplied by 200,000. So in would just represent the number of injuries or illnesses or lost work days. EH is representing the employee hours worked by all employees during that calendar year, and then where they are multiplying that out by the equivalent. So BLS also computes 4 incident rates for each industry, so 4 different rates for each industry, one being total recordable cases. The second one is recording days away from work. The third one is days of job transfer or restricted work. And then the last one is just other recordable cases. So depending on the severity of the injury or illness, they might just have to be completely out of work. So that's where those days away from work come in. They might just have to have work restrictions, so light duty, maybe it's only desk work, something like that. And then sometimes they're not out at all. Like maybe they go to the doctor, they get checked up on, they say, you're okay, we've checked everything, you can be back to work tomorrow. Fantastic. There was no missed work. So there are various levels. Just make sure that you're tracking all of those. The OSHA forms do have like spots to record all of that. So even if you don't remember, that should help trigger what you would need to look up. All right. Let's see what else on this thing before we jump forward into the next thing. All right. I think we're good. All right, so employees have a right to request an OSHA inspection if they believe that their job duties or working conditions pose a threat to their well-being. OSHA protects employees from discharge and discrimination when they report. So regardless of whether they report the complaint to the employer, OSHA, or outside parties, that would be like the press, like if they go to the news or something like that, all of which should be free from any type of retaliation. So specific worker rights, they have the right to participate in union activities related to job safety. This may be like serving on safety committees or acting in concert or protest job safety. Acting in concert or protest job safety and health hazards. Employees or their representatives have a right to participate in OSHA inspections, conferences, other hearings. Employees also have the right to refuse to work if they reasonably believe that their working conditions pose an imminent risk to death or serious injury, and there is not sufficient time or opportunity to seek effective redress from the employer or OSHA. So if it's something just too fast, you kind of have to make a game time decision. Those are probably few and far between, and most of us probably are not dealing with that. There's elements to some of these that I think of like super high risk jobs, like maybe it's high line workers or something like that, where they're like climbing these giant power lines or cell phone towers, things like that. Those are substantially higher risk. I'm sure there's a lot more potential for something like this to come up in those regards. But typically speaking, people can make a report. It can result in an investigation. With all of that said, OSHA, like many governmental agencies, my understanding is pretty short-handed. So the likelihood it would be if it's like a substantial report, but they're probably not just going to like pop out for a surprise inspection without otherwise having some sort of report made. All right, so let's talk about record keeping. Okay, so all employers, regardless of size or industry, must report any accident that results in death of an employee to the nearest OSHA office within 8 hours. Okay, hopefully none of us are ever dealing with a death on our hands from a job-related activity, but it is possible, so we all have to know this. There are very specific timelines. So within 8 hours to your nearest OSHA office. Hopefully if something like this happened, you're going to have your legal counsel on the phone pretty quickly, and they will probably be walking you through this as well. All work related inpatient hospitalizations, amputations, loss of eye must be reported within 24 hours. So there too, like, so, okay, they're not dead, but they had to be hospitalized or they're having a limb amputated. Those are also extremely severe and need to be reported rather quickly. Additionally, work-related injuries for accidents that result in any of the following also have to be recorded. This follows the list there: loss of consciousness, again, days away from work, restricted work activity, or medical treatment beyond first aid. So first aid has to be defined here. First aid meaning literally you just need some ointment and a Band-Aid. Or something, I sometimes look at it even, again, this is back to my teaching days, like if it's something the school nurse could do, it was probably just first aid. I know school nurses are like licensed nurses, I understand that, but typically speaking in a school environment, they are not fully practicing like they would if they were in like a hospital type environment. So it's usually very simplistic, right? You just need a little Band-Aid, or, you know, just go take some aspirin or what have you. So simple first aid does not have to be recorded, but if it is anything beyond that, and if at all in question, consider it beyond that. I personally take the stance as it relates to any of these reporting. If I'm not 100% sure, I'm going to err on the side of go ahead and report it rather than not. And by reporting, it is not terribly difficult, assuming that it's not something as severe as needing to report it within 8 or 24 hours. For example, many of the incidents I've usually dealt with have involved like somebody slipped, they fell at work, they maybe slipped on a wet spot on the tile or something like that, or tripped over some cords that weren't properly secured, and their hip hurts or their shoulder hurts now or something of that nature. You report it, you send them to a doctor to make sure that if they need an x-ray or an exam or whatever it may be, that they get checked out. If they need just like a muscle relaxer, that they get that prescription. And you just report it on a form. It's not terribly difficult. You run it through your workers' comp just in case they need additional treatment, and that way their treatment is covered. But otherwise, it's not terribly difficult. So at least in my experience, a lot of it was centered around like slips and falls. I've had a few others here and there, but especially even at the hospital, it was a lot of slips.
So I was going to ask, when you said from a job related activity, if it's an office type environment, a slip and fall would be something you would have to report like this, and not.
He's still, again, I tend to err on the side of caution. I've even talked to my legal counsel about this, and it's like, if it happened within our office, we would consider ourselves responsible, right? So we tend to err on the side of, yes, we would go ahead and consider it, whether it be workers' comp. Like I said, usually too, like if you just go that route from the get-go, the employees usually are just like, okay, great. Like, and again, I've had employees too, kind of, Tyler, to your point, where they like don't want to go get a drug screen. Sometimes they also really don't want to go get an exam. Like they're like, no, I'm fine. Like I don't want to report it. I don't want to go anywhere. Which, I mean, they do have a right to refuse that. It's just then if it's 3 days later and now they're like, gosh, I'm still in pain, it's a little trickier there, right? So I just make sure people know what they are waiving if they choose not to go get it addressed sooner rather than later. But yeah, we tend, for us at least, we tend to err on the side of, if it was on property or one of our events or something like that, that we likely would still take that route. I even had one situation not too terribly long ago where an employee was driving like from like an off-site team meeting, or no, they were coming from their home to an like a lunch with the team that did not require their presence. They were told, you do not need to be here. They asked to go. Like they were like, no, I want to, I'd like to do that as kind of like an opportunity. And in that time in the car, got in an accident. And I was like, where does that fall? Like they weren't required. It wasn't technically required of work. They didn't have to be doing that, you know? And even then, for, again, those purposes, our legal counsel was like, I would just cover it. Like, unless you feel super strongly, which you will probably have some counsel that would be like, absolutely. Like, did we have to? Maybe not. Does it probably come off better to just be like, yeah, we'll cover it? And in this case, the employee was like, I really don't want to keep doing that. Like, I don't want to go. Like, I'm fine. Or, you know, they went to one appointment. It said they had to have a follow-up a week later. And so I was, of course, staying on top of it. Like, hey, I need an updated you know, note from the doctor. Did you go see them? Blah, blah, blah. And, you know, at one point they were like, I'm done. Like, I'm like, okay. And I just documented that, like, did not go to follow-ups, like no longer, you know, gonna deal with this claim. And I just let our workers' comp know that they refused further treatment. And I guess they closed the case or whatever they do on their end. But yeah, that was kind of a weird one too. So I feel like now with pre-COVID and people working from home, or because there too, that begs the question of, well, what if they hurt themselves in their own house? But I don't have control of how their office setup is. So that's a very much an area to work with whether it be your workers' comp agents or your legal counsel to determine how you are going to process that. And then just being consistent. I think that's really the key, is if you cover it for one, you should continue covering it. And if you're not, if it doesn't, you know, fall under workers' comp, then it doesn't for anybody. But yeah, it's a unique area. Like I said, we have so few, we tend to just call it workers' comp, cover it in OSHA, and just move on with our day because it's easier. But in the hospital, we didn't. Great question. Does that help? Okay. All right, let's talk about what is not required. Yes. Sorry, I got ahead of myself on a note there. So what is not required? Medical treatments, that, like I said, for instance, just literally anything that's could be labeled first aid, visits to a healthcare professional for observation. So just to watch, that does not fall under this, or diagnostic procedures, including prescription medications that are used solely for diagnostic purposes. So this is information you just have to ask about, or get in documentation from the healthcare provider, that either you partner with and maybe you use. I know at least for us, like I kind of, OSHA and workers' comp for us typically go hand in hand. Because if I'm sending them for some sort of, if it's OSHA, they're probably going to see some sort of medical professional. Therefore, my workers' comp is going to come into play. And with that, I usually try to have like a singular provider that we like to send them to, that sends the documentation back to us and has our account and knows how to file to our insurance, things of that nature. If you don't have something like that, I would suggest maybe it's not a high priority if you don't have a lot of cases, but it's easier if you set that up before you need it. Just so you know, this is where you're going to go. This is the form I have to send you with. This is the information they're going to need, that sort of stuff. Like have it pre-prepared in a packet. That way, if you're doing it, or even if somebody else is having to do it, because maybe you're out, they have a roadmap and aren't like, well, I don't know, I guess just call your general practitioner. And it's like, well, what if that takes them 5 days to get into their general, or they're calling teledoc who's like, nah, I don't do workers injury. Because that's always the first question is this a work related injury? So have a plan. If you don't have a plan, it's okay. I would recommend creating a plan before you need it. So start having some of those conversations. Most of the clinics like Care Nows and stuff like that, they'll create an employer account and kind of help walk you through that process. Or again, talking to your workers' comp company and seeing how they recommend guiding you through that. Okay, so let's talk about OSHA forms, because we've talked about how you do have to report things of that nature. So for each recordable injury, or illness, it has to go on the form 301. This is just an incident report. It must be completed within 7 calendar days of the injury, or you being aware of the injury, because sometimes people don't report it right away and you might not find out about it until 3 days later or however long. So once you do, go ahead and get that done. Employers must also catalog all injuries on the OSHA Form 300. This is just a log of all of the injuries you've had within a calendar year. Employers then summarize the log on the Form 300A and at the end of each year. And then this is the one that typically gets posted at your organization. And they're supposed to be posted from, I have it in my notes. So the 300A has to be posted from February 1 to the end of April for the year prior. So any of us who had injuries should have one posted right now for 2023. And if you don't, you could get it going now. Doing anything in good faith is always the best approach. It's okay if you haven't been doing it correctly otherwise. And then we keep the log and the summary for 5 years. So having a way to keep track of that. If you have no idea what these forms are, just Google them. Google the Form 300, the Form 301, OSHA has them. It's a PDF. You literally can just fill everything in. The log is like an Excel spreadsheet. Some of the information you can just keep pre-populated in there. Other pieces you'll be updating based on the injury itself. So like the 301 is specific to that person and that injury, whereas the log is basically just that. I mean, it's a summary, right? So the templates, if you use their stuff, it will feed into the other forms usually if you have it. So it's not difficult. Probably one of the easier parts of the job. Now, again, if you're having a lot of injuries, it can become just very cumbersome. But the forms are very straightforward, pretty easy to work through. and then you just file them away separate from the employee files. Because just like any other type of medical files, they should not be kept directly in the employment file. They should be kept separate, like with where leave forms and stuff like that are as well, since they are health related information. Any questions on that? Like I said, the forms, definitely go Google them if you don't know what they are, and it's okay if you don't. Google them, keep them ready to go, templated, ready to use. It does make it just, again, a lot easier if you actually have an emergency, that things are already, you know, saved either on your company server or wherever you keep your documents, that they're ready to go and you know exactly where to go pull them. Or again, if you're documenting your procedures in case someone else is doing it and it's not you or your HR team, you want to have those templates ready for them so they know exactly which forms to fill out. That's more so if it's really an emergency. Typically, it can wait until we get back to the office and we can fill them out for them. All right, cool. Oh, I was going to mention on the forms. So not every, here too, right? I probably create a little more work for myself than I need to do, but it's also because at the hospital I did have to do these. Most workplaces with 250 or more employees are required to, especially at high-risk industries, are required to keep all their forms. Certain high-risk industries, even with just 20 employees, are required to submit their forms. So there too, do a little research for your particular industry. For example, ours is not high risk anymore, so I'm not required to submit forms, but that is kind of I think a somewhat newer. I still post them. Like right now we have ours up even though it's 0. And I'm not required to put that out there, but it's not hurting anything. I already had to keep the log, so I just throw it up on the bulletin board where all the other posts are. And that way people do know, hey, we didn't have any, because they're not going to hear about it. It's not like we're tracking safe days at our office. But that way, if somebody does come across it, they can look at it, and that's perfectly fine. So otherwise, like I said, check your industry, check with your company size, make sure you know what is required for you to truly report on, and what maybe just needs to be posted internally. Okay. Let's jump into checking safety inspections. So OSHA can conduct workplace inspections to enforce their standards. Since, again, they don't have a lot of time to conduct annual inspections of every workplace, they do prioritize what environments they would go to. So probably not surprising, at the top of the list, imminent danger situations. So these are always going to be the highest priority on their list for obvious reasons. So if you are not an industry that would be considered a lot of imminent danger, you probably are, your risk is going down, right? And then after that would be just severe injury and illness. So things that might result in hospitalization, amputations, and for whatever reason, losses of eyes is a big one on the OSHA legislation. I'm not sure why the eye is more specific than other parts of the body, but it is. And then after that, work complaints or worker complaints, is going to be third on the list. Beyond that, referrals, targeted inspections, and follow-up inspections. So again, honestly, from what I heard and understood, probably the top 2, 3 at most are what they're going to get through. 4 through 6 are very unlikely, not impossible, but very unlikely that they're going to make a visit. Does anyone happen to know where the closest OSHA office is to us here in Fort Worth? They are also, like many of our other governmental agencies, not far. Okay, they're not far. You know, we got DOL close. We have lots of our government agencies right in our backyard. OSHA has an office in Richardson. So not like right here, but they're in the DFW Metroplex. So if they really needed to, if they had the ability and needed to hop out and do an inspection, we are not far. So that also would play into the risk, right? So if there was a place, you know, that severe injury may be had and they're in the DFW Metroplex, higher probability than if you lived out in El Paso, maybe, or just in the middle of nowhere. All right, so let's talk about imminent danger. This is defined as any condition where a high probability exists, then an accident may occur that will result in death or serious physical harm. If the condition is found and not corrected, OSHA can apply to the nearest federal district court for temporary restraining order, and operations could immediately be shut down. So again, this is for a company though who's not going to be compliant with correcting whatever the situation is, whether it's exposure of something on a machine that employees are working right beside or something of that nature, and they refuse to put a protective shield or whatever the case may be. Beyond, like I said, that's kind of the main thing, is just understanding what imminent danger is and understanding that obviously if you do not comply, you likely could be, your operation could be shut down. So also that some other examples of imminent danger might be, I'd already spoke about malfunctioning of a machine, like a heavy machine. Another one might be poisoning from lethal gas. So again, thinking about just the area, or if people work with gasoline, things of that nature, that has the potential to cause serious injury if it's not handled properly and it's not dealt with properly. So those things are going to have a higher risk. All right, so criminal penalties. Violations of OSHA standards can be very costly. So there are 5 different levels of violations under the Act. One being just that, de minimis, where there's really no direct relationship between safety and health, safety or health. So there might be little things here and there, like we all have things we could do better, cords that could be put away differently. That's pretty de minimis. Like, it's fine, there's no penalty, just let's try to get it cleaned up. Other than serious violations is the second one. This would be a direct relationship to safety or health, but still unlikely to cause physical harm. So this one in particular could cost up to, at last I checked, it was over $13,000 potentially, up to, right? It didn't have to be that much. And then serious violations, substantially probable that there could be death or physical harm. So these have a mandatory penalty of up to the 13, it's a little over 13, it's like $13,494. But it also can be adjusted if the employer in good faith has tried to make adjustments or hasn't had other previous violations, things of that nature. So again, sometimes it's just, if things are brought to our attention, making good faith efforts to try to correct it can get us in the good graces of the OSHA investigators. Then, of course, you have willful violations, just that. You knew about it and you did nothing about it. These penalties can be upwards of $134,000, almost $135,000 for each violation, or as long as 6 months in prison if it resulted in death, because at that point you knew about it. That's not good. There can also be individual fines up to $250 for an individual or $500 for a corporation, and may also be imposed criminal convictions. So nobody wants a willful violation, that's for sure. And then, of course, repeated can also start stacking the financial violation, or the financial amount that is due for each violation. So pieces to keep in mind. I do have notes that very common citations, and some of them I've already talked about: fall protection, hazard communication, respiratory protection, scaffolding, and ladders. Because like OSHA has a law that rungs of a ladder have to be 12 inches apart. And so, like, for example, a de minimis violation might be if at a company they were using a ladder and the rungs were 13 inches apart. Like, okay, it was wrong, but it's unlikely it should be that big of a deal. So it would likely be a de minimis violation. But technically speaking, OSHA says it should be only 12 inches apart. So there you go. All right, I think that's what I had on that. Any questions on the penalties, the violations? Questions, concerns? Okay. All right, so I spoke just a minute on, or just a second ago, on hazard communication. OSHA does have a standard on hazard communication that requires employers to notify employees when hazardous chemicals are present in the workplace, as well as train employees to work with them safely. So again, if you've ever worked in a healthcare environment, you probably are aware of this. Like, we had to have a binder about all the different things. And even as a teacher, I mean, here too, right? Like, as a teacher, sometimes when we were doing science, and if we were mixing different things, we had to have a whole training on that so that we knew. And we had to have, if you've ever walked into like a chemistry lab, either at high school or college, and they have like the shower thing and all that stuff. So you have to train people on that. You have to make sure they're aware, even if they are not going to be the ones, shouldn't be the ones using it, they still need to be aware. This standard applies to all employees who may be exposed to the chemicals under normal working conditions. It also preempts all state and local right to know laws, except those established in states and jurisdictions that have OSHA approved state programs. So yeah, there's a data sheet, there's chemical labeling standards, there's a variety of things. So if this pertains to you, I would recommend you make sure that you are aware. And if you're not, go do a little research, ask the rest of your HR team, or like I said, go to the OSHA website and do some research of your own and just make sure you're up to standards. For most of us, it probably does not apply. But just be mindful of it. Even like if you have your own, like if you don't outsource your housekeeping or in your cleaning at the office at your like physical location, even some of that sometimes can fall into this, depending on what type of cleaning chemicals they're using for that particular staff, at least, right? So it's not necessarily everyone, but if you don't outsource that, that might be something that you need to think about. Okay, again, very common in healthcare, chemistry, schools. I know for sure, I'm sure there are others, but those are two in particular that I know it comes up. Great, so let's talk about safety training. It is effective. All employees, supervisors, and managers should receive adequate safety training. Employees should never be allowed to perform a job until they've been authorized to do it and have received adequate job instruction. So again, this is especially true if they're working with machinery or with things that could more likely expose them to injury, not rushing through onboarding. We've all had the supervisor who's like, but I need them now. I don't have enough people on the team. I need them to just come on and you do orientation later and we'll deal with that later. I'm like, no, you got to assess that and what they're doing. So in some cases that might be just a hard no. Absolutely not. We cannot do that. Again, like for ours, they're going to a desk. Yes, I probably need to teach them about, your workplace setup and ergonomics and stuff, but they're not like dealing with forklifts and potentially harm someone. So there's variations of that. Accident statistics indicate that new employees are much more likely than long-term employees to be involved in an accident. Probably not super surprising, but why we need to do proper training, give enough time, and make sure that they have the tools and resources to be safe on the job. So keep that in mind. Great. First aid training. According to OSHA, an employer must ensure prompt first aid treatment for injured employees, either by providing for availability of a trained first aid provider at work on site, or just ensuring emergency treatment services are within reasonable proximity. So if you're somewhere in the Metroplex, you're probably okay. But if you're in a super remote area, you would want to make sure somebody is properly trained to be able to provide that if it were ever needed. For serious injury, first aid treatment must be provided within the first few minutes to avoid permanent impairment. And OSHA recommends that every workplace include at least one employee who is trained and certified in first aid, which would include CPR. So if you do not have somebody that falls within that, you may want to think about going through that training either yourself or sending somebody else, whatever the case may be, but making sure that somebody is available. Unfortunately, so I could even say, again, not very long ago, we have had situations where at least one, it's maybe even two, but I've had employees have a seizure on site. Thankfully, these individuals had shared that piece of information with me in advance that this was something that they deal with. So, I mean, we already at least had, some protocols in place and things of that nature, but at least then, if it were to have happened at work, I felt a little more prepared having at least knowing that, which otherwise, if an employee doesn't require accommodation, it can be hard to have that information if they don't openly share it or feel comfortable sharing it. Because in this case, there are no other accommodations. They weren't requiring or asking for anything. They just thankfully had shared, this is a part of something that, I deal with. And just in case it happens here, I want y'all to be prepared. So that, again, we can seek proper medical treatment as timely as possible. So if you ever have that or many other things, there can be a whole variety of things. People have shared that with you. Just make sure, even if it's not that you have some plans, what you would do. Think about that before it happens. You know what the plan of action is going to be once you are notified of what's happening. I think another piece that I don't recall if I put in somewhere else, so I'm going to talk about it now, just in case. But as it relates also to any type of healthcare that somebody may need due to an injury or even just an illness or what have you, always take the approach here too. I've had employees in the past that they're having a medical emergency. Well, think of when you call the doctor's office, right? And they're like, if this is medical emergency, please call 911. Please do that, because I have had situations, thankfully it's been a while, but I had to learn from them, where there was a real medical emergency. The person was still coherent, they were able to communicate with me, and they were like, no, you don't need to do that. You don't need to call 911. I'll be fine. But, even if they're just having trouble breathing, if their breathing is very labored or what have you, and they're trying to wave you off, that tends to be the common thing I've seen is people no, I'll be fine. I just need a few minutes. Or it's just call my spouse or call my mom or whoever. I'll be fine. Just have them come pick me up and take me home. Here is my piece of advice, and you can take this, you can leave this. It won't hurt my feelings either way. Call the medical professional. Last I checked, most of us in HR are not licensed doctors, not even nurses. We have no medical experience. We cannot practice medicine. We don't know how severe things are. I would rather call in a medical professional, an EMS, whoever it may be, to assess the situation and determine, oh, they're okay. They need a few minutes. We're going to stay here with them while they catch their breath or while they eat a snack or whatever it may be. And they don't need to seek further treatment. Great. That's fantastic. But who am I to know that that's okay? Other times, and in this one in particular, they needed an ambulance. They did. And looking back, I made the wrong decision. I listened to the employee. I did not call the ambulance. Thankfully, it worked out okay. The person was okay. I should have called the ambulance, let them assess the situation. If that employee refuses to get in the ambulance, that is their choice. But at least someone who has the knowledge, education, skill set to be able to assess that situation is doing it. That's not me. It's not me. Like, and it's probably not you guys either. Like, we are not trained for that. That is not in our job description. It is one thing to throw a Band-Aid on somebody. It's another to decide whether they need or don't need further medical treatment if they are what seems like having a medical emergency. You best believe somebody's having a seizure, I'm calling 911. They're going to send me an EMS, and those EMS workers will determine if they are okay. If they'll check blood sugars probably and see if they need some sugar or what it may be. If you have diabetics in your employee population, things of that nature. Just know what your lane is. That's my advice. And like I said, I unfortunately had to learn it in a situation where I feel like I actually did not make the right decision. I would not make that decision again today. I would always call. I would make them turn away the medical help than me not have called it and something happen on our watch, because that's a much higher risk to both me and our company. That employee can be mad at me. And I think a lot of it sometimes comes down to they're kind of embarrassed. They don't want an ambulance to come. Like, I get it. I empathize with that, but I cannot decide if you are good to stay here and work. I can't decide if you do need to go to the emergency room. I can't decide how if you're about to have a heart attack, but I'm not going to take that risk again. So if you do nothing with that, that's okay. I'm just sharing my own experience, and I haven't made that mistake a second time. It was a one-time deal. So, but it is something to keep in mind. Again, you've got to kind of think through those scenarios. In the case when I was first faced with it, I don't think I'd ever thought about that happening. Ever. It just hadn't crossed my mind that I would be in that situation. So I didn't know what to do. Unfortunately for me too, there were other medical professionals there who thought they could just handle it, which also not their job. They were not, a patient of that facility. You cannot do that. These sorts of things. So there were a lot of dynamics in play. Okay, with the end of that story, we're at 8 o'clock, which is perfect because next up, we're going to be getting into some accident investigations. And we made it pretty much halfway through the slide deck. So I am confident we will finish next week, possibly even a little bit early, just depending on if there's more conversation or questions or what have you. Otherwise, does anybody have anything before we depart tonight? Right. Well, y'all have my email if y'all need anything. I will probably send out some questions next week to prepare us going into next week's conversation, and we will wrap this all up in a pretty bow on is it the 11th? I don't know what day it is next week. 11. Good. 4 plus 7. Yes. Carry the 1. Got it. Fantastic. I hope you all have an amazing week. Enjoy this beautiful weather this weekend. And let me know if y'all need anything.
Thank you.
Thank you. Good night. Thank you.
Julie, I was just going to tell you, in the book we got, it looks like the penalty went up to 15,000 on the serious or other than serious and serious.
Okay, perfect. I'm glad you said that. I should have done my homework and gone and double checked that.
No worries. So then willful also went up to 150,000, not
I'm
100.
not surprised. Honestly, most of those are so low, employers wouldn't even bat an eye at them.
Right.
They'd be like, great. Where do I send the check?
Yeah. Well, thank you for everything.
Yeah, no problem. Thank you always for sharing. I appreciate it.
Of course. Definitely trying to learn and get as much as I can from this. So thank you.
Yeah, absolutely. Well, let me know if you need anything in between. Happy to help or have conversation. And I hope you have a good night, Tyler.
Awesome. You too.
Bye.
Bye.